Good morning, everyone. I want to welcome you to the bankruptcy training for pro bono lawyers. And so I just wanted to first of all welcome you and thank you. I think I've spoken to probably all of you on the phone ahead of today's training. So it's nice to see your faces here in person. The bankruptcy clinic is the only provider of pro bono bankruptcy services in the District of Columbia. And so your participation in this training in the clinic is vital to our ability to provide pro bono bankruptcy services to low-income debtors in DC. So just a couple of things about where we are. This is part of the DCBar pro bono program. With our very small staff, we're on track to place about 60 pro bono bankruptcy cases with volunteer lawyers this year. We do not provide any bankruptcy services ourselves, our staff, so all of our services are provided by you, by volunteers, and we do not receive any DCBar funds. So all of the work that we do is possible because of volunteers like you. So again, thank you for your time. This training is sponsored both by the DCBar Pro Bono program and with the assistance of a very generous grant from the American College of Bankruptcy. So we'd also like to thank them for their support of this training. A couple of logistical things. There is a training contract in your materials. I think all of you know that by agreeing to take the training, or by taking the training, you're agreeing to accept 2 bankruptcy cases through the DCBar Pro Bono Program's bankruptcy clinic. There's also a training evaluation. We'd really appreciate your feedback on the training itself. And we'd also appreciate your feedback on the application and interview process as well. There is not a specific question about that in here, but if you have any feedback or suggestions for that process, please do include them here so that we can consider that as we prepare the training for the next session in December. We'd also like to thank Dixie and Shapiro because they contributed the manual, which we used for the first time during the last training session in December. And so we're very appreciative for their help in developing it. And with that, I'd like to introduce Jeff Sherman, who's our training chair, and has been for as long as I can remember, maybe as long as he can remember as well. Jeff is a solo practitioner. He's a bankruptcy lawyer with over 30 years of experience in DC, Maryland, and Virginia. He's practiced with a number of firms and in the last couple of years has set out on his own. He is great, as you'll find out today. He never makes me feel silly, no matter how silly the questions I ask him, and I'm sure that you'll find that to be true with him today. He served as a bankruptcy trustee, has represented numerous debtors and creditors in bankruptcy proceedings, and it has tons and tons of experience that you get to benefit from. So I learn something every time I talk to him, and I know that you'll learn a lot over this 2-day training. So I'll be back this afternoon to talk with you about the referral process, how we place cases through the Pro Bono Program Bankruptcy Clinic, about working with clients in poverty. And if you have any questions about pro bono practice, I'll be able to answer those then. I will also have 7 bankruptcy cases ready for placement. So, and Jeff will tell you this as well, think about taking one today if you at all can. You can read the case file tonight. You can come back on Thursday and ask Jeff all of your thousands of questions. And then it also puts the training in a really great context for you because you'll have some facts to think about with it. So I'll be back to see you this afternoon and glad to answer any questions that you have at that time. Thank you so much. Thank you, Jeff.
Thank you. Good morning, everybody. Welcome to our bankruptcy training for pro bono attorneys. As Leah said, my name is Jeff Sherman. The purpose of this 2-day training is to acquaint you with the basics of bankruptcy, both on the law side, which is more of today's presentation, and on the application or the practice or the paperwork side, which is really what Thursday is all about. Bankruptcy is, as a general proposition, extremely paper-driven. Your typical Chapter 7, and we'll talk about the kinds of bankruptcies in a few minutes, but the typical Chapter 7 bankruptcy that you guys are going to pick up through the pro bono office here, you will never see a judge. There will never be a reason for you to have to litigate anything. It's simply a matter of getting the right paperwork filed, having one meeting, which is not even held in a live courtroom. It's held in an abandoned courtroom or unused courtroom in the courthouse and isn't in front of a judge. It is designed to be a very streamlined process that is driven governed and effectuated by the proper filing of paperwork. And you will see that your manual consists of an awful lot of forms. And the good thing is that these forms are available in a variety of ways, including for free on the bankruptcy court's website, through a number of commercial packages that you can license the software to use to do electronic filing. For pro bono cases, it isn't necessary that you do your filing electronically. I would highly recommend it, though. The training is not that difficult. After lunch today, we're going to have a presentation actually by the clerk's office for the DC Bankruptcy Court, because one of the things that we are very, very lucky here in DC, although this is a very low filing, a low volume jurisdiction, it's one of the 4 or 5 slowest. What it means is that the clerk's office, although they are not heavily staffed, they do have the flexibility to develop, and they have spent a tremendous amount of time, as has the judge here in DC, getting the website to be extremely user-friendly, extremely dense in content, with everything from literally videos of lawyers interviewing clients who are considering bankruptcy. Now, mind you, they're actors, so, you know, they're even more stiff than lawyers are when they do that. But that's how densely packed the website is. And the clerk's office is going to come here and spend about an hour or so explaining that process, introducing you to the website, showing you where to find stuff. Literally, we could spend a day going through that stuff, but I've asked them to compress it down. So the website will be introduced to you, you'll be introduced to it, and you'll have a chance to see what it offers to you. The course is broken down to 2 days because of people who have been through it before. This used to be, if you can believe it, a 1-day course. And besides being a 1-day course, a big chunk of the time was still spent on explaining bankruptcy law. And what was happening was that the forms part would come at the very end, and we'd spend an hour or two at the very end trying to cram in all the stuff about how to fill out the forms, how to get the information from your clients to fill out the forms, what forms were necessary. The number of forms over the years has expanded as different interest groups, and that's my political bent, different interest groups have influenced the content and practice of bankruptcy law. And we were finding that people were understanding certain aspects of bankruptcy law and missing out on the part where we explained to them how to actually do the bankruptcy filings for the benefit of the bankruptcy clients you get either by referral here, or if you go on in private practice as a bankruptcy practitioner, full or part-time. This training should carry over to explain these forms for you. So the way we've gotten the feedback from previous training sessions is the green form that's in your paperwork. And for those of you who've taken other CLE or DCBar courses, I know every speaker preaches to you about the importance of feedback, but I will give you the same speech. We really do tinker with every aspect of this class from time to time, and the only way we can do it is by finding out what works and what doesn't work. And the only way we know that is if the people who are the recipients of the magnificence of our training tell us whether or not we're on track, missed the mark, need to expand, contract, go to a 3rd day, which a lot of people have said because the information is pretty dense. So please, 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 it is very important to us and to me especially, because I've been doing this now for 9 years. We have booted speakers, we have invited speakers because of the feedback we get and the importance of making sure that you walk out of here at the end of the day Thursday equipped to know what to do substantively and procedurally with your pro bono referral. While it's not interactive, your feedback as we go is important because I want to make sure you guys get this so that when you do have that first phone call or first meeting, it's not something scary, it's something that you are just waiting for. You know, I used to play tennis many, many years ago. And the teacher I had when I was a teenager used to tell me that when you're waiting for your opponent to hit the serve, which is typically the hardest shot that you're going to get, You can stand there and go, oh my God, he's going to hit it. Oh my God, what am I going to do? This ball's going to come at me 150 miles an hour. And you stand there terrified, and the result is that your reaction time is slower. And my instructor said, if you just stand there instead and in your head get the thought, come on, hit that ball because I am waiting for it. I am ready for it. Whatever you've got, I'm ready for it. You're more on your toes. And that's sort of the philosophy here. I want to make sure you guys are anticipating and looking forward to meeting the people whose problems you're going to help solve. And I will tell you the experience we get from the people we mentor, and that's another thing we do. After this class is over, both myself and my assistant, who will be here on Thursday, Aaron, we are available to you to answer specific questions, and they always come up. And as Leah said, there are no stupid questions. So you get the benefit after this training, in your specific case, to call or email, and we will try and provide you input. And we do it all the time, and we've been doing it for some people for a period of years. So don't hesitate to utilize the resource. We want to make sure not only that you're equipped, but along the way you get everything ready. Okay. Can I just see very quickly a show of hands for anybody who has been involved in a bankruptcy case already of any type, creditor, debtor, trustee? Okay. All right. Let's talk about bankruptcy generally. First, I apologize in advance. Usually I get up and walk around because I believe in the philosophy that a moving target is harder to hit. But because of the videotaping, I am going to have to sit. That's great for my back, but it means that the droning that I do is going to be even more boring than usual. At least you get to watch me go back and forth on days when we're not videotaping it. All right, let's talk about bankruptcy generally as an overview. Bankruptcy, first of all, is federal law. It is part of the United States Code. There is no state law of bankruptcy. Now, having said that, there used to be state law on bankruptcy, and there are still state law procedures which look a lot like bankruptcy, like an assignment for the benefit of creditors, which you never see used anymore, which is kind of like a bankruptcy. But the Bankruptcy Code is part of the United States Code. It's Title 11 of the United States Code, and it is federal law. And in fact, because we have a permanent bankruptcy code that came into effect in 1979, federal preemption says you can't have a state bankruptcy code. In fact, we have had a permanent bankruptcy law since 1898, and at the time that it was effectuated, there were a number of state bankruptcy laws, and they were all wiped off the books because Article 2 talks about how Congress has the power to pass uniform laws on the subject of bankruptcy. I think it's bankruptcy and immigration, which is an odd combination. But so it's a federal power. It's exercised under Title 11 of the United States Code. And although there has been a long history of litigation over the jurisdiction of the bankruptcy courts, there are separate bankruptcy courts in every district in the country. There is a bankruptcy court for the District of Columbia. There is a bankruptcy court for the Eastern District of Virginia. There is a bankruptcy court for the District of Maryland. In Maryland, there are two divisions, Greenbelt and Baltimore. The Eastern District of Virginia has multiple divisions. The one with which we concern ourselves here is typically Alexandria. That's the Alexandria division. There's a Richmond division. There's, I think, a Newport News division. But in DC, there's only one court, one district, one division, one judge. And that's Judge S. Martin Teal, Jr. He has been on the bench since February of 1988. And that means that this man knows his stuff. He has been around the block. And while we are not as sexy and complicated as the Southern District of New York or the District of Delaware with their airline filings and their chain store filings and their complicated real estate investment trust filings, we have a judge who has experience, tremendous breadth and depth of experience in the kinds of cases that do come up here, including virtually every consumer case issue that you'd want to come across, as well as a lot of Chapter 11 cases, real estate cases. We now have a gigantic hospital case that was transferred here from the District of Delaware. Some of you may remember the Greater Southeast Hospital was a very large bankruptcy here. For those of you who are old enough, you may remember United Press International. That was a bankruptcy here in the 1980s. So we've had our share of big cases here. And as I said, Judge Teal's been on the bench now for 26 years. So he knows his stuff. He is, I should tell you, an extremely strong supporter of pro bono work, and is very deferential to pro bono attorneys, and will make sure that both his courtroom and his staff do everything possible to ensure that lawyers who are volunteering their time are respected for their undertaking and are accommodated at every opportunity. You will find, for example, today's presentation by the clerk's office is a function of the fact that Judge Teal, who used to teach here, has said to them, take the time, make the time, send your people down, because these are the people who are going to be filing the cases, and we want to make sure they know as much as possible. So it's federal law in Title 11, but the bankruptcy law is also found in really two other places. First is bankruptcy jurisdiction, like most federal jurisdiction, is found in Title 28. But unlike things like federal question or diversity, which are 28 U.S.C. 1331 and 1332, the bankruptcy jurisdiction is 28 U.S.C. 1334. In addition, and this is where the jurisdiction of the bankruptcy court becomes problematic, the bankruptcy courts are not Article III courts. They are not created under the judicial power granted under the Constitution. They are created under the legislative power in Article II, just like the tax courts have been established as Article II specialized courts. So, for example, Judge Teal here in D.C. does not have lifetime tenure. He's appointed for a 14-year term. He's been appointed twice to two 14-year terms. The difficulty arises because in the context of a bankruptcy case, it may be necessary to try and adjudicate issues that have nothing to do with bankruptcy law specifically. In those cases, the parties to the case may be entitled to have their case heard by an Article III judge and not by a judge in a court of limited jurisdiction. So Title 28, besides having Section 1334 as the basis for the court's jurisdiction generally, also has a provision in Section 157, which defines something called a core, C-O-R-E, a core proceeding. A core proceeding is a proceeding which involves bankruptcy issues, issues arising under the bankruptcy law specifically, which otherwise would not be in a bankruptcy court, but for the fact that there's a bankruptcy case pending. So, for example, we're going to talk about how debtors, individual debtors, get a discharge from their debts. Well, if there's litigation over a bankruptcy discharge, there's no provision for the discharge of debts other than under the bankruptcy law, so that's a core proceeding, litigation over discharge. If there's a question about whether or not a debtor owns a piece of property or has an interest in an asset, well, that wouldn't be in front of the federal courts except for the fact that there's a debtor in bankruptcy with a property interest. That's a core proceeding. And a core proceeding is one which the Supreme Court has said the bankruptcy courts can actually enter final judgments, just like a tax court, just like a federal district court. However, the appeal from a bankruptcy court goes to the district court, not to the Court of Appeals, but an appeal from the bankruptcy court first goes to the federal district court. That's in core proceedings. The alternative to being a core proceeding is to be a non-core proceeding. And for non-core proceedings, the bankruptcy courts can't enter final judgments. They can only enter proposed findings of fact and conclusions of law. And then a federal district court, the federal district court here in D.C., has to determine whether those findings of fact and conclusions of law are legitimate and proper and appropriate, and the federal district court will enter judgment. So you have core proceedings that are bankruptcy issues that the bankruptcy court can adjudicate finally, and you have everything else which the court can try but not enter a final judgment. The federal district court has to enter the final judgment. That's the most confusing part of bankruptcy court jurisdiction, and now you've mastered it. Okay, Besides Title 28, which has the general bankruptcy jurisdiction, and Section 157, which defines what cases the bankruptcy court can decide, you also have Title 18. Now, some of you may remember, and some of you may have experience in dealing with issues that come up under Title 18. That's the criminal part of the federal code. And there are bankruptcy crimes specifically related to bankruptcy case administration. And if you take a look at 28 U.S.C. 151 and 152, you will see the kinds of things that constitute bankruptcy crimes. And they're the sorts of things that you typically would think of, like trying to bribe a party to a bankruptcy case, concealing property so that the creditors or the court can't get jurisdiction or can't administer the asset. Things like that are within the ambit of Title 18, Sections 151 and 152. So the bankruptcy law is found in Title 11, principally. Jurisdictions in Title 28, and the criminal aspect of bankruptcy case administration is found in Title 18. Okay. There are different kinds of bankruptcies, and these are called chapters. And everybody who's heard the news over the last 10 years especially has heard about these different chapters because they've gotten a tremendous amount of play in the news with the real estate crash, naturally. Let's talk about the ones we're not going to talk about here. There is a thing called a Chapter 9. I mention it because it's in the news, because Chapter 9 is a special bankruptcy procedure just for governmental units like cities, municipalities, school districts, water districts, that sort of thing. So right now, Detroit is in a Chapter 9 proceeding. There's a big fight about whether or not Chapter 9 is constitutional. It is. Chapter 9 proceedings were extremely rare back in the 1980s. All kinds of water districts in California had to file Chapter 9 because they were running out of money because of various droughts and overuse and forest fires that drained all of the water, so they couldn't basically sell the water to generate revenue. So Chapter 9 is there. Greenwich, Connecticut, I believe, filed a Chapter 9. The District of Columbia talked about filing a Chapter 9. I believe it was when Mayor Dixon, Sharon Pratt Dixon, was the mayor. They were considering a Chapter 9 filing. So it's there. We're not going to talk about it here because there are no pro bono Chapter 9 filings. Another chapter that is out there that we're not going to deal with is called Chapter 12. Chapter 12 is a structured repayment just for farmers. Now, you occasionally get them in Virginia, you occasionally get them in Maryland. We have yet to have a Chapter 12. I am sure at some point, some creative bankruptcy lawyer here in DC is going to find somebody with a private house who's got a vegetable garden in the back, and they're going to call it a farm, and they're going to try and file a Chapter 12. Thus far, we haven't had it. So we're not going to talk about it, but it's out there. The last kind of case, the last kind of chapter proceeding that I want to mention is what's known as Chapter 15. Chapter 15 is a provision of our bankruptcy law that implements an international insolvency law, a cross-border insolvency law. The United Nations established a working group whose purpose was, among lots of other things, to create an international, a cross-border insolvency law so that all countries would know exactly how to administer a bankruptcy case involving assets or creditors in multiple jurisdictions. So, for example, we have had cases where a company in Germany that's headquartered in Germany owns a manufacturing plant in the United States. Well, the German courts don't have jurisdiction over American assets or American debts or American creditors. So the United Nations adopted what's known as UNCITRAL, UNCITRAL, UNCITRAL. the United Nations Compact on International Trade Law. And among the provisions of UNCITRAL is the model law on cross-border insolvency. That model law has been adopted here in the United States as Chapter 15. We're all sitting around waiting for Chapter 15 cases because they are among the most interesting that you will ever encounter. And every once in a while, a Chapter 15, an international issue, because this is a very international city, does come up. Again, I would love to spend a full day just talking about how it works. But there are very few pro bono Chapter 15 cases, and you're not going to get one here. By the way, if in your practice you do run into the Chapter 15 case, please call me and let me know, because I'd really like to know how it goes. Okay, so those are the ones we're not going to talk about. Let's talk about the ones we're going to talk about. First of all, there's Chapter 7. Now, Chapter 7 is also known as a straight bankruptcy or a liquidation. And it is basically what it sounds like. Chapter 7 is the process by which a debtor comes into the bankruptcy court and says, I do not want to pay my debts. I want to discharge. I want to walk away from my personal obligation to pay my debts, in exchange for which you can go ahead and liquidate my assets and distribute that money to creditors right now. Because once I get my discharge, that discharge bars creditors from ever coming back to collect those debts from me. So what they don't get from me now, they're never going to get from me. So a Chapter 7 case is about liquidating a debtor's assets and distributing the money to the creditors. And that's it. That's all Chapter 7 is about. So when you have a pro bono client who wants to file a Chapter 7, the first thing you know is, I don't have to worry about this debtor's long-term financial commitments. I don't have to concern myself especially with their car loan or their mortgage. I just need to concern myself with ensuring that their assets and their liabilities at the time of the filing of the Chapter 7 case are thoroughly documented, completely disclosed, and are protected to the extent possible, so that if there are assets to be liquidated, they are liquidated, but otherwise the debtor gets a discharge, has no personal liability for their debts as a result of the filing of a Chapter 7 case. So Chapter 7 in philosophy is very, very simple and straightforward. The alternative to Chapter 7 are two other chapters. Let's talk about Chapter 13. We're going to talk about it in some detail. Chapter 13, like Chapter 12, is a court-supervised and court-approved debt repayment plan. Usually runs 3 to 5 years, and the court has to approve the repayment plan. So Chapter 13 is not focused on the discharge. Chapter 13 is not so much focused on the assets and liabilities of the debtor at the time of the filing, because the debtor is not simply walking away from the debtor's debts in Chapter 13. In Chapter 13, the debtor is proposing a repayment plan. That repayment plan is going to run over a period of years. So in Chapter 13, the focus is less on assets and liabilities and more on income and expense. And if the debtor has excess income each month, that money is going to be used to pay back the debts through Chapter 13. So Chapter 7 is about assets and liabilities, liquidating assets, walking away from liabilities. Chapter 13 is about repaying debts over a period of time based on income and expenses. So that's the principal difference between the two of those. In addition, and certainly not least but last, is Chapter 11. Now, I'm going to be doing, for example, a 4-week program for the DCBar this summer explaining creditors' rights in Chapter 11. Just creditors' rights in Chapter 11. That's going to take 4 weeks. We can't do Chapter 11 in the context of this sort of training. And it's not a case that you're going to get by referral here, but it's important you know what Chapter 11 is, and I'm sure, again, if you've heard the news, you know that Chapter 11 is typically the big, complicated business reorganization. Chapter 11 reorganization is what Chapter 11 is all about. It is a restructuring of the assets and liabilities of the Chapter 11 debtors and the proposal of a repayment plan, unlike in Chapter 13 where the court approves the Chapter 13 plan. In Chapter 11, the creditors vote on the Chapter 11 plan. If they vote to accept it, typically the court approves it. If they reject it, the court has some options, but typically if the creditors don't vote in favor of a Chapter 11 plan, the plan doesn't go anywhere. Chapter 11 is large, expensive, time-consuming. I remember I was involved in the Macy's case. That was in the Southern District of New York many years ago. And the debtors' lawyers who were there were asking the court to bless their having been retained for purposes of doing the Chapter 11 case for Macy's, for Federated. And some of the creditors objected because the law firm was an expensive law firm, and they got up there and said, this is going to be a $100 million fee case. And the attorney for the proposed debtors' lawyers, for Federated's lawyers, Macy's lawyers, got up there and in righteous indignation pounded the podium and said, this is not a $100 million fee case, this is only a $75 million fee case. And everybody said, oh, well, okay, in that case, that's fine, no problem, it's not $100 million. But you can see that Chapter 11 is intended for and has been used for, American Airlines has been through bankruptcy, has been through Chapter 11 a couple of times. I don't know how many of you remember Braniff. Braniff went through bankruptcy, Chapter 11, a couple of times. Eastern Airlines went through Chapter 11 a couple of times. Continental went through Chapter 11 a couple of times. U.S. Airways went through Chapter 11 and went through it here in Alexandria. So Chapter 11 is designed to accommodate huge, complicated cases that are oriented towards preserving jobs, preserving assets, and finding a way to maximize the return to creditors. So that's what Chapter 11 is about. It's out there. The Supreme Court has said consumers are eligible to file Chapter 11 cases the same way consumers are eligible to file a Chapter 13 case, and consumers are certainly eligible, with certain limitations we'll talk about, to file Chapter 7 cases. But the fact of the matter is, if a consumer requires a Chapter 11 case, they better have very, very complicated holdings. And a lot of them do. If you look on the docket here in DC, as well as in Greenbelt and Alexandria, you will see a lot of individuals who file Chapter 11. And the reason is that they don't qualify for Chapter 13 because Chapter 13 has certain limits on eligibility. They don't want to liquidate everything in Chapter 7, so their only alternative is Chapter 11. And they go through that Chapter 11 process. And I will tell you, just in my experience, even the simplest Chapter 11 case for a consumer is going to be $15,000 to $20,000 and a year's worth of work. Not every day, but a year to get that case off the ground, pitched to the creditors vote, and the court approves it. So it's out there, but it's pretty rare that a consumer needs to file a Chapter 11 case. Most typically you see Chapter 7s and Chapter 13s. We'll be talking about Chapter 7, and we'll be making references to Chapter 13 throughout, because Chapter 13 is the first alternative to a Chapter 7 if someone for some reason is not eligible for Chapter 7. Okay, so those are the different chapters of a bankruptcy proceeding. What I also want you to do is I want you to know who are the players that are involved in a bankruptcy proceeding. I keep mentioning the debtor. It used to be under the old bankruptcy law that was in effect before 1979, which was called the Bankruptcy Act of 1898, that the person or entity that was filing bankruptcy was referred to as the bankrupt. And in the 70s, Congress established the Bankruptcy Commission to look at revising the bankruptcy laws. And one of the things that this Bankruptcy Commission obsessed over was not calling bankrupts bankrupt anymore. Now we call them debtors because that's a somewhat less pejorative term. They're simply debtors. Debtors are simply people who owe money. You can be a debtor outside of bankruptcy. You can't be a bankrupt outside of bankruptcy. So the word was regarded as too pejorative and was replaced with debtor. So the person or entity that's filing the bankruptcy case is the debtor. Typically there's only one debtor. The exception would be that husbands and wives, and now same-sex married couples, can file a bankruptcy case jointly. But other than that, there's one debtor, whether that debtor is an individual, a corporation, a partnership, a union. Now, there are certain exceptions to the identity of potential debtors. And if you look at Section 109 of the Bankruptcy Code, you will see it's called, I believe, who may be a debtor. So that's pretty instructive on who may be a debtor. And things like railroads can't file bankruptcy. Railroad holding companies can, but railroads can't. Banks cannot file bankruptcy, although bank holding company, and you can always spell a bank holding company because they spell bank with a C, not a K. That's how they get around that. Insurance companies can't file bankruptcy. They have to be liquidated under the insurance commissioner for each jurisdiction. Stockbrokers can't file bankruptcies, although the procedure to liquidate a stockbroker is almost identical to the bankruptcy code under the SIPC, Securities Investor Protection or Procedures, something. So you can't have those kinds of debtors, but otherwise, a real estate partnership can, a business trust, a business, not a family trust, but a business trust can file a bankruptcy proceeding, and as I said, individuals can. Relatives cannot file unless it's spouses. So we had a case here actually where a mother and son tried to file a joint bankruptcy case. The mother's portion of the case was dismissed, the son's case was allowed to proceed. Another thing that can't file bankruptcy, and we get this question a lot, is, and it sounds kind of funny, but dead people can't file bankruptcy. Decedents' estates cannot file bankruptcy. And sometimes a bankruptcy would be the best thing for somebody's estate because of the debts that are left by the decedent. But there was a case, if I remember correctly, it's called In re Brown, B-R-O-W-N, very early on, like around 1980, that the judge who was on the bench at the time said, no, you can't have a decedent's estate file a bankruptcy proceeding because there's a separate proceeding for that. So the debtor is the person or entity that files the bankruptcy case. Yes?
What if somebody dies after filing a bankruptcy case?
Okay. There are a couple of ways to approach that, and it depends, number one, on the chapter. So for example, if you have a Chapter 13 debt repayment plan and somebody dies in the middle, it's not possible for them to continue to fund a plan after they've died. So a Chapter 13 case is very likely to be dismissed or converted to a Chapter 7. If someone dies in the middle of a Chapter 7 case, it really depends on how far along has the case progressed. Are there still things that the debtor personally would have to do as a participant in their own Chapter 7 case to make it fair under the circumstances to allow the case to proceed to discharge? And it's a case-by-case deal. And when we talk about Chapter 7, you'll see there are timeline events that require a debtor's participation. If all those timeline events have passed and they are simply waiting for the entry of a discharge, it's almost certain that they're going to let the debtor receive a discharge after their passing. That discharge would be effective in the subsequent estate that the person, decedent's estate that the person leaves behind. But if the case is early on and they haven't hit those timeline events, most likely the case would wind up being dismissed and the administration would go on into decedent's estate. But we do get that question, and it occasionally does happen. Okay. So that's who may be a debtor. Now, in Chapter 7, in every Chapter 7 case, without fail, in this jurisdiction, in Alexandria, in Greenbelt, in Baltimore, in Richmond, in fact, in every Chapter 7 case, in every jurisdiction, I believe, except North Carolina and Alabama, there is appointed automatically a bankruptcy trustee. Now, I'm going to refer to this person as the bankruptcy trustee or the trustee or the Chapter 7 trustee or the Chapter 13 trustee. But a trustee is appointed in every Chapter 7 case. And here in D.C., there is a panel of 4 individuals who rotate serving as Chapter 7 trustees in whatever cases are filed that particular week. And we're going to talk about specifically what the duties of a Chapter 7 trustee are, but keep in mind, what's the purpose of Chapter 7? It's liquidation. So a Chapter 7 trustee's mindset is totally focused on whether or not the debtor has assets that the trustee can liquidate to pay the money to the creditors. And if there are no assets, then the trustee's job is basically over. In Chapter 13, there is also a trustee. And we have one Chapter 13 trustee, and her name is Cynthia Nicholas, Niklas. And she has been the Chapter 13 trustee here, I'm going to say, for 30 plus years. And she also knows every permutation on Chapter 13 that all the creative bankruptcy lawyers have been able to come up with in that time. And her job as a Chapter 13 trustee, or the Chapter 13 trustee, is to simply make sure that the debtor's income and expenses are right and correct and accurate. And then her job is to receive the monthly payment made by or on behalf of the debtor. Typically it comes out of their paycheck automatically like a garnishment. And to distribute that money to the creditors based on what the Chapter 13 repayment plan says, to pay certain creditors certain amounts of money over a certain period of time. So you have the Chapter 7 trustee whose job it is to liquidate assets and distribute the cash. And you have a Chapter 13 trustee whose job it is to receive the monthly payments and distribute that money to the creditors. In Chapter 11, by the way, there is no trustee automatically appointed in a Chapter 11 case. In a Chapter 11 case, somebody has to come in and ask for a trustee to be appointed. It does not happen automatically. And the presumption in favor of leaving the debtor in control of the Chapter 11 case is pretty strong, so that the threshold to get rid of a debtor and replace the debtor with a trustee in Chapter 11 is really pretty high. Take a look at, I believe it's Section 1104 of the Bankruptcy Code, which talks about the appointment of a Chapter 11 trustee. So a player you absolutely are going to encounter besides the debtor, your client, is the Chapter 7 trustee. And as I said, there are 4 here in DC. And that trustee's job is just to determine if there are assets to liquidate. In addition to the Chapter 7 debtor and the Chapter 7 trustee, you will also have creditors. Now, there are several different kinds of creditors, and we're going to be talking about them in a variety of ways. So let me tell you what the kinds are for bankruptcy purposes. The first kind of creditor is what's known as a secured creditor. Now, if you learn nothing else out of the 2 days that we're going to go through all this, let me tell you, the fact that a creditor may have multiple debtors, may have the right to go after a guarantor, may have the right to go after a co-debtor, the ability to proceed against someone other than the debtor does not make them a secured creditor. Don't use the term, they're secured by the guarantee of so-and-so, or they're secured by a co-debtor's or co-signer's agreement to be liable. Secured creditor, the term secured is a term of art, meaning explicitly and specifically that the creditor has collateral that has been pledged to the creditor. So what kind of debts are secured debts? What kind of creditors are secured creditors? Mortgage holders are secured creditors because the real estate has been pledged as collateral to the creditor. An automobile finance company is a secured creditor because they have the title to the vehicle pledged as collateral. When you buy jewelry from a lot of jewelry stores, when you sign the receipt, you are signing a security agreement, which gives the jewelry store's finance arm a lien on the jewelry that's being purchased. That jewelry finance company is a secured creditor. When you buy furniture on time, when you go and get one of these clear title loans that you see advertised on the non-premium cable channels at 2 o'clock in the morning, those people, when they take title to your car as collateral, become secured creditors. If you don't have collateral, you are not a secured creditor. Just because you can go after 10 people, all of whom signed your note, does not give you collateral. It gives you additional recourse, but it does not give you collateral. So, secured creditors have collateral. Without collateral, you're considered an unsecured creditor. And that means you don't have a right in a specific asset that's been pledged to you. So there are secured creditors, and there are unsecured creditors. Now, among unsecured creditors, the bankruptcy code says there are some who are more worthy of payment than others. And if you take a look at section 507 of the bankruptcy code, you will see that there is a statutory order of priority. Who gets paid first when the dollars are available in a Chapter 7 liquidation? And the answer is 507 tells us the exact order. Not surprisingly, the first person who gets paid is the Chapter 7 trustee, who gets paid for his time and trouble. And then there are various other categories of debts, including things like domestic support obligations are very high priority, wages that are owed to employees, very high priority, all the way down to things like the claim of a fisherman to the value of their fish in a common fishery is a priority claim. Remember I talked about special interest groups tweaking the bankruptcy law? That's one example. Grain warehousemen, for the value of their grain in a common granary, are entitled to be paid ahead of other general unsecured creditors. And taxes are paid ahead of general unsecured creditors. Now, the kinds of claims that get that preferential treatment are referred to as priority claims, and that's the title of Section 507, claims entitled to priority. And all it means is that Congress, in its infinite wisdom, has said there are certain claims which we want paid ahead of all other claims of the similar type. So creditors are secured creditors, priority unsecured creditors, and general unsecured creditors. And what would be examples of general unsecured creditors? Credit card bills, doctor's bills, personal loans. Again, anything that doesn't have priority and anything that doesn't have collateral, you can safely assume is a general unsecured creditor.
Where do student loans fall involved with this?
Okay, student loans are general unsecured creditors. The holders of the student loan claim is a general unsecured creditor, and unless they have collateral, which would be extremely rare. There is no priority in distribution for student loans. So for bankruptcy purposes, student loans are considered just like credit cards and doctor bills. They are general unsecured creditors. Now we're going to be talking about, remember I said in Chapter 7, the object is to get that discharge where the debtor can walk away from the debtor's pre-bankruptcy debts. Well, some debts cannot be discharged. The determination of whether a creditor is secured, unsecured priority, or unsecured non-priority has nothing to do with whether the debt is dischargeable. If a debt is dischargeable or not just determines whether or not the debtor gets to walk away. It has nothing to do with the priority or collateral that a creditor's claim is entitled to in that bankruptcy proceeding. Okay? Now, student loans, and we'll talk about this at much greater length, student loans automatically survive Chapter 7. They are not dischargeable. But in a bankruptcy, the Chapter 7 case, the student loan is considered a general unsecured creditor. Why? It doesn't have collateral pledge. It is not entitled to priority. So the holder of a student loan claim would be entitled to be paid through the Chapter 7 case if there's money, along with all the other general unsecured claim. The only difference is the holder of the student loan claim, to the extent it's not paid, its claim will survive the discharge. Nobody else's will, because credit cards debt get discharged, all those other general unsecured debts get discharged, but the student loan claim will survive and can be collected against the debtor after bankruptcy for the statute of limitations. So you have secured creditors, priority unsecured creditors, and general unsecured creditors. Okay. The parties that you see are the debtor, the trustee, and the creditors. There's another party which has sort of an omnipresence, and that's called the Office of the United States Trustee. It is a very poorly named agency because it is not really a trustee. The U.S. Trustee's Office is an agency within the Department of Justice. And the U.S. Trustee's job is to oversee the administration of the bankruptcy process. They don't oversee the judges, they oversee the conduct of the debtors and the trustees. In fact, the U.S. Trustee's Office is the place where that list of Chapter 7 trustees is established and maintained. Their job is to make sure that the Chapter 7 trustee is doing his job correctly. They will actually go in and do random audits of Chapter 7 trustees to make sure they are maintaining their books and records as trustees correctly. The Chapter 7 trustee is appointed by the Office of the U.S. Trustee and can be removed by the Office of the U.S. Trustee. The Office of the U.S. Trustee also will examine what goes on in a Chapter 7 case in terms of the conduct of the debtor, because there are certain things that a debtor might do in a Chapter 7 case, or Chapter 13, or Chapter 11, or Chapter 12, or Chapter 9. There are certain things that a debtor may do which may violate the law, may violate the rules of procedure, and the U.S. Trustee's Office has the power to come into the bankruptcy court and say, you know what, the Chapter 11 debtor is not abiding by this court order. You need to appoint a Chapter 11 trustee, or you need to dismiss the case, or you need to convert the case from an 11 to a 7 because the Chapter 11 debtor can't be trusted. They can't account for their money properly. So the Office of the U.S. Trustee is an administrative office, but it is not the Chapter 7 trustee. It is not the Chapter 13 trustee. Those are different people. There are 4 Chapter 7 trustees, 1 Chapter 13 trustee, and above them all hangs the Office of the United States Trustee. We'll talk a little bit more in detail about what they do a little later. Okay, the next concept I want you to get down, besides the identification of the debtor, the trustee, the creditors, the U.S. trustee, is what's known as the bankruptcy petition. Now, the bankruptcy petition, and you'll see, and we're going to talk about how to fill them out, but the bankruptcy petition, you'll see it in your material, is a piece of paper. It can be filed in physical form, it can be filed electronically, but the bankruptcy petition is the piece of paper. It is the document that starts the bankruptcy case. No matter the chapter, that case is commenced by the filing of a bankruptcy petition. There are 2 kinds of bankruptcy petitions. There's a voluntary petition where the debtor decides it or they or he or she wants to file a bankruptcy case under one or another chapter. They would file a voluntary petition. And the date that they file that voluntary petition is what we call the petition date. And you will hear references to pre-petition and post-petition. And that's what it refers to. The pre-petition and post-petition terms refer to the filing, the date and time of the filing of the voluntary bankruptcy petition. No matter the chapter, the date that the voluntary petition is filed establishes the pre-petition period for everything that was before that, and the post-petition period for everything that follows. There's another kind of petition, and that's called an involuntary petition. And this is extremely rare, but occasionally a debtor will not know that the jig is up, but the creditors will. So the creditors can get together and say, even though the debtor refuses to accept it, we want the court to start a bankruptcy case on behalf of the debtor, not at the request of the debtor through the filing of a voluntary petition, but through the request of creditors who file an involuntary bankruptcy petition with the court. And again, the involuntary petition creates a pre- and post-petition yardstick. The difference is, when a voluntary petition is filed, the case actually starts as of that moment. When an involuntary bankruptcy petition is filed, the bankruptcy court has to have a trial to determine whether or not to start a bankruptcy case. So the creditors file involuntary bankruptcy petition against a debtor, which is the same thing as a request to the court to start a bankruptcy case. And the bankruptcy court will, as quickly as circumstances permit, have a trial on an involuntary petition to decide whether or not to start a case against a debtor. If an involuntary petition is filed, the debtor can always agree to it and turn it into a voluntary case. Involuntary bankruptcy petitions can be filed under Chapter 7 and 11. They cannot be filed under Chapter 13 because of the 13th Amendment, which says that you cannot be forced to work for someone else's economic benefit. So you can't force somebody into a Chapter 13 case. You can only have a voluntary Chapter 13 case. If someone is put into a bankruptcy involuntarily, they can voluntarily convert to a Chapter 11 or a Chapter 13. But you can't have an involuntary 13. You can only have a voluntary 13. You can have a voluntary or involuntary 7 or 11. So those are the two kinds of petitions, voluntary and involuntary. The filing of the petition on a voluntary basis starts the case. The filing of an involuntary petition is a request to the court to start a case. When you have a voluntary petition, it establishes pre- and post-petition periods. Same thing for an involuntary case. It starts a measure for the pre- and post-petition periods. Voluntary petitions, as I said, can be filed by entities, and we talked about who can be a debtor, and the same voluntary petition, one voluntary petition, is all you need to file spouses jointly. And you will see that the form, and we'll be talking, like I said, in considerable detail about the form is set up to be a universal form for individual debtors, for joint debtors, under every chapter. The only thing is there's a different form for an involuntary case. So you'll be seeing a voluntary petition, which we will go over line by line, so you know exactly what goes in every box, whether it's information or a box to be checked. So you can have a voluntary individual or voluntary joint petition, or you can have an involuntary individual or joint petition. So those are that's the concept of the petition, the pre-petition and post-petition periods. Next, I want you to understand that when a bankruptcy petition is filed voluntarily, or in the case of an involuntary, when the bankruptcy court says, yes, there should be a bankruptcy case commenced with respect to a particular debtor, then what is created is this legal fiction, a term lawyers love to throw around, legal fiction called a bankruptcy estate. And it's just like a decedent's estate. When someone passes away, there is created this legal fiction of the decedent's estate. Well, in bankruptcy, under Section 541, whenever a case is commenced, which is either by the voluntary petition or because the court starts a case involuntarily, a bankruptcy estate is created. And all of the debtor's assets, all of the debtor's property, whether it's encumbered by a lien or a mortgage, whether it is individually owned or jointly owned, whether it is worth a penny or $1 billion, whether the debtor owns it as tenants in common, tenants by the entirety, joint tenants, individual, fee, whether the title is legal title or equitable title like a beneficial interest, every asset in which the debtor has any legally recognizable property interest starts off as property belonging to the bankruptcy estate. Property of the estate, it is extremely broad and extremely inclusive. There are very, very few things which are not part of a bankruptcy estate. And if you look at section 541, it'll say the bankruptcy estate consists of everything except. So you start off with the assumption that when your voluntary petition is filed, it creates a bankruptcy estate, the debtor's estate. And that estate consists of all of the property interests of the debtor as of the date of the petition. All of the debtor's pre-petition assets become property of the estate. The Chapter 7 trustee's job is to liquidate property of the estate and pay the creditors. So that's the bankruptcy estate. Typically, when you have a debtor, and especially consumer debtors, who owe a variety of creditors, those creditors are taking steps to enforce or collect upon their claims. Either they're making phone calls to the debtor to try and, I'm going to use the term, talk them into paying, or they're getting sued, or they are in jeopardy of foreclosure or repossession, or they're about to have a garnishment come into effect on their paycheck. But creditors are exposing the debtor to some kind of danger, harassing phone calls, harassing mail, legal action, enforcement of secured creditors' rights. The filing of a bankruptcy petition and the creation of a bankruptcy estate, the appointment of a bankruptcy trustee, all of those are great. But if the creditors were able to still go after the debtor and the debtor's assets, then whatever the assets are that the debtor has would simply be eaten away by creditors who successfully attach bank accounts, garnish pay, foreclose, or repossess. So upon the filing of a bankruptcy petition, voluntary or involuntary, in every case, with only one exception, the debtor and the debtor's assets and what becomes property of the estate is protected by what's known as the automatic stay. The automatic stay is a very strong, very powerful statutory injunction against creditors. When you file a voluntary petition, when you file an involuntary petition, not only does the clerk's office stamp it with the date, the district court will stamp a complaint that you file with a date, but in the bankruptcy court, they will also time stamp it, because the automatic stay comes into effect at that moment when the voluntary petition or involuntary petition is filed. As of that moment, the automatic stay is in effect. No question about it, with one exception, which we'll talk about later. But the automatic stay is in effect, and creditors, as of that moment, are enjoined by statute from taking virtually every and any action whatsoever to enforce their claims or enforce their secured creditors' remedies. The automatic stay automatically stops foreclosures, which is why, although there are no foreclosures anymore in DC, you used to see so many people running to bankruptcy court on the eve or the morning of a foreclosure, because as of the minute the petition is accepted by the clerk for filing and stamped, as of that minute, they and their assets are protected by the automatic stay, and that foreclosure is enjoined by the automatic stay. Litigation that's been proceeding against the debtor is automatically enjoined by the automatic stay. How do you implement that? You notify the trial court through the filing of what's known as a suggestion of bankruptcy, which tells the court and the parties to that litigation that the debtor has filed a bankruptcy petition and is now protected by the automatic stay. Creditor phone calls If your client is receiving threatening phone calls from collection agencies or from creditors, and you tell that creditor or that creditor's representative that the debtor has filed a bankruptcy and is now under the protection of the automatic stay, as of the time of the filing of the petition, that automatic stay has been in effect, and the creditor must respect the automatic stay and must stop calling the debtor. The creditor must stop sending threatening letters. The creditor may not start a new piece of litigation. The creditor may not start a foreclosure. The creditor may not go and get a writ of attachment or a writ of garnishment. All of those things are barred by the automatic stay. So you can see that the automatic stay is tremendous motivation for debtors to get in under the protection of the bankruptcy code by filing a case and having the automatic stay become automatically effectuated. Yes?
Do garnishments that are ongoing, are they automatically stopped?
Yes. In fact, in DC, Judge Teal requires that the lawyer for the creditor, or the creditor if it's pro se, notify the payroll office affirmatively that the garnishment must stop. In practice, it may take quite a bit of yelling and screaming on your part as debtor's counsel to get the creditor's counsel to recognize this obligation, but Judge Teal does not mess around with this sort of thing. There's an affirmative obligation on the part of the creditor to stop the garnishment. If they don't, if anybody violates the automatic stay, it's punishable as contempt. The automatic stay is set out in Section 362 of the Bankruptcy Code. And you'll see under the tab significant statutes, we've reproduced 541, 362. 362A talks about all of the kinds of actions which are barred by the automatic stay. 362B talks about the things that are excluded from the automatic stay, things that can still go on even though a bankruptcy petition has been filed. And we're not going to go through the whole list, but just to give you an example, a taxing authority, DC, the IRS, even though someone has gone into bankruptcy, can still assess, not collect, but can still assess a tax liability. That tax liability is part of the bankruptcy, but the taxing authority, the IRS or DC, can still make an assessment. Criminal cases are not barred by the automatic stay. Criminal cases can continue. You may find that you have a client who is being prosecuted criminally, for example, for non-payment of sales tax related to a business, or having issued an NSF check, although criminal prosecutions for that are exceedingly rare. If that's the case, don't think that filing a bankruptcy petition is going to get them out of that criminal liability or is going to stop that criminal trial, because it's not. And 362B contains a continuing list, and it seems like there's a growing list because special interest groups have their particular thing that they don't want covered by the automatic stay. So for example, if a lease has expired before a bankruptcy case has been filed, the landlord can continue with an eviction, but only in that specific case. If the lease hasn't expired, then different things happen. And that was put in by the Mall Owners of America because they wanted to be able to evict tenants whose leases expired, who were just hanging around and they want to get a new tenant in there. So 362A talks about what's in the automatic stay. 362B talks about what's excluded from the automatic stay. And there are other subsections of 362 that we'll talk about. But let's go back for a second. The automatic stay, as I said, is automatic federal statutory injunction against creditor action. And then finally what I want to talk about is something that came into effect in 2005. In 2005, there were massive changes made to the bankruptcy code. And I will reveal my political bent by telling you how this happened. For many, 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 many years, and I mean many years, like 20 plus years, the creditor lobby, particularly the credit union lobbying group, Credit Union NA, MBNA, before it was part of Bank of America, now Bank of America, were actively trying to make it harder for individuals to file bankruptcy. The argument being that if an individual filed bankruptcy, that the creditors were taking the loss. And the argument was, all of these people, they can repay some portion of the debt, so they shouldn't be allowed to walk away from their debts. And for years and years and years, the creditor strategy was to lobby Republican legislators to try and get the Republican legislators to push through stricter and stricter limitations on the ability of individuals to go through bankruptcy. And they failed. And they failed session after session, legislature after legislature, they failed. Somewhere in early 2003, somebody on the creditor lobby said, why aren't we giving money and lobbying Democrats? There gotta be some Democrats that we can persuade. If we can get a few Democrats, and we know we have all the Republicans, then we can get our anti-debtor bankruptcy reforms through. So what did they do? They became heavy contributors in the 2004 election cycle. And lo and behold, we had the bankruptcy amendments of 2005. It didn't take long. And these are some pretty stupid and some pretty extreme burdens that are placed on a debtor before the debtor can file and go through a Chapter 7. And we'll talk about some of them, but in my mind, one of the worst is, for the first time in history, although it had been rejected for over 105 years, we have means testing for eligibility for Chapter 7. You have to pass a means test in order to qualify for Chapter 7. And the means test is a form. It's reproduced in your materials. We're going to be talking about how to fill it out on Thursday. But now a debtor must complete and must establish their eligibility to file a Chapter 7 case. And very simply, the means test says if the debtor's income is below the median income for their household size in that state, then they can file Chapter 7. So in DC, I just happened to have looked this up in the last couple of days. In DC, the median income for a household of one is $46,460 or $464. $46,460. That's the median income for a household of one in DC. Household of two is a little more, household of three is a little more, but that's the one that I remember off the top of my head. If your debtor's gross income is less than $46,460, then they're automatically eligible to file Chapter 7. If their income, gross income, is above $46,460, then you get to go through the entire means test form and deduct certain things from their gross income to take a second shot at eligibility. So they get to deduct the taxes that are withheld from their paycheck, they get to deduct mortgage payments, car payments, they get to deduct amounts for food, gas, clothing, insurance, tuition, all kinds of things, all of which is in the means test form, which, like I said, we're going to go over in detail on Thursday. But once you have gross income above the median, and you take all those deductions that you're allowed to take for your household size, you get to then look to see, have you brought your net income below that $46,460 household of one median income? And if you have, by taking all those deductions, then the debtor is eligible for Chapter 7. So the means test for DC starts off with the household size and the median income for that household size. And then you look at the debtor's gross income. If that's below the median, you're safe. If it's above the median, you go through the process of taking all of the deductions and look again. If the debtor's still above the median income, the debtor may not file Chapter 7. The debtor is not eligible for Chapter 7. What happens if you have a debtor who needs to be in bankruptcy? 13 or 11. They get forced into some other kind of proceeding that they may opt for, or they can choose not to file. And you remember I said you can't have an involuntary Chapter 13. The courts have said telling somebody that their only choice for bankruptcy is a 13 is not the same thing as forcing somebody to work to repay their creditors. So there's nothing violative of the 13th Amendment in saying you're not eligible for Chapter 7. You're only eligible for a bankruptcy where you repay your debts, where you work to repay your creditors. Yes?
How is the income level determined and what scale are they using?
Okay, the Office of the United States Trustee that I mentioned before, on their website, they actually have a pull-down menu of every jurisdiction in the country, and it extends out, I think, to households of 6 or 8. The amount, I think, changes twice a year. And it is a mathematical computation that is done, I believe, either by the Department of Justice or the Department of Population Analysis, whoever does that, simply to determine what the mathematical computation of the median is. Now, the things that you get to deduct if your gross is above the median and you have to do that analysis, things like the amount of dollars you get to deduct for food, the IRS has guidelines. They're not realistic. They bear no relation to the real world. But the IRS amounts for a household of 3 to pay for food, that's the amount that is plugged into the means test in order to determine what the deductions would be to try and bring the income down. And again, those are available. You can vary from them. I mean, for example, if you have a household where someone has a special diet for medical needs, and the cost of that diet, for example, a diabetic diet, vastly exceeds what the IRS says that the household expense for food on a monthly basis should be, you can explain, if somebody asks, why there's a variance. But otherwise, you simply plug in the numbers that the IRS, in its infinite wisdom and lack of comprehension of what real life is like, and I'm going to get audited for that, what they say, your clothing, transportation, food, housing. For example, they have an amount in there for what your housing should cost if you're paying rent in D.C. And anybody who thinks that the rent in D.C. is reducible to one number has got to be crazy. The rent in different neighborhoods is going to be extremely variable. But the IRS has a dollar amount that you can plug in for rent. One number. So that's the means test. All right, this is a good time for us to break. Let's break for 10 minutes, and then we'll come back and talk briefly again about the U.S. trustee, and then we'll move on to Chapter 13.